the blues run deep. Crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story untold, she thinks she's clever, but I'm on to her game. I'll expose her ways and put her to shame.
Hey-oh, and welcome. I've been swamped up to my eyebrows in work the last week. I managed to get a few streams last week, but not on Friday. So we have a bit to catch up on the young Thug RICO-Trial. So, let's get this show started. Welcome to the show. That was the wrong one. That was the outro, not the intro. Okay. Boomering already. Yeah. What we are going to watch is a bit we'll just try to catch up from last week and yesterday, and maybe, just maybe, we can catch up to today's show. I don't know. Depends on how interesting it gets. But let's see here. Dun, dun, dun. Let's see what happened on the afternoon of day 74. Yeah. Let's see here. That one? No. What's going on now? Darn it. There. That's better, because then I can... Oops, sorry. There. Now we're ready. All right. Let's go. Play 1.25.
I think that he's going to be getting confirmation because his status in law enforcement.
Is he still employed as a law enforcement officer?
In the use capacity.
He's an undercover.
Yeah, they claim a witness later on is an undercover agent. That's not entirely. He used to be. Let's just say that.
Any defense counsel wish to be heard about that issue? Mr. Harvey.
Is it on? Okay. I would object to him testifying off camera. I haven't heard any reason that suggests that the constitutional rights of an open trial should be curtailed.
Okay. Anyone else? All right, Mr. Harvey. I'm going to over your objection. Given the fact that he's an undercover officer, I will permit him to testify in this open forum, but he just won't be videoed. He will still be audioed and otherwise. All right. Okay, what specific issues do we need to talk about in terms of, are there any videos or any other evidence that we need the court needs to look at?
Judge, I don't think that there are, other than I think the one that Mr. Adams brought up, the third Jeffrey Williams
Is
video.
that one going to be shown through Detective Racy?
That one may be shown through Detective Races.
All right, don't need to take a look at that one, but what about any other videos or pictures or social media posts or anything like that?
There are other social media posts, Your Honor, if the court would permit me just one moment to look through our list of exhibits for those matters. Just 1 second.
All right.
Yeah, and as per usual, this will be a little bit of a spoiler. This was the end of last week where, oh, this social media post, that video, and we will learn that yesterday morning. They just happened to extend that list. Isn't that surprising that all of a sudden, no, we will add on these two. So first they give to the defense, we are bringing up this. And yeah, so of course the defense prepares for that.
Social media footage, Your Honor. I also wanted to make certain that the court is aware of.
So the defense prepare for that, of course, as you do. And then, surprise, we are using these two. She is so dishonest.
3 other, I think, jail calls from Jimmy Minfrey that we intended to introduce. But I also wanted to, if I can, just instruct everyone on the record how to access it without us having to convert them so that it's clear. You don't have to have extra stuff. I can tell everybody how to use that.
The last time that you attempted to do that, or your office attempted, okay. See how she sold you out that quick, Mr. Atkins? All right. Just want to point that out to you, right? Last time we had some challenges with that video conversion. So can we ensure that that gets done so that everyone within the sound of my voice in this courtroom can go ahead and access that?
Yes.
And if they have a specific objections, they can be flagged?
Yes, it's not a conversion, but I'll do that on after, or I'll just sort of do a round table. And I'll also tell Mr. Kearns how to access it without it being converted with the media that you have.
How long are these 3 jail calls?
I think about 15 minutes each. We're converting them anyway, the 3 of them, but I still wanted to make the court aware.
It would be helpful if you did that so I could listen to them beforehand.
We're doing that. As a matter of fact, that is what is being worked on.
And when will that be done by?
We can have that by in the morning, Your Honor, if that's okay with the court, so that after
In the morning, by what time, Adam?
11 o'clock.
Okay. All right, what else?
Yeah, Ms. Hilton just informed me that
He being who?
he being Detective Racy, he does not mind being filmed, so we can withdraw the need to not have him on camera.
Okay, then, and you can let our media.
Yes, he let the prosecution know, oh, he doesn't mind being filmed. And why was that? Well, the claim from the prosecution was he's an undercover. No, he is not. He hasn't been an undercover cop for quite a good number of years.
Friends know, who's ever here on Monday, that he may be on camera. So that satisfies one issue. All right, and then so the 3 jail calls you're gonna make available, make sure everyone can play or give instructions by 11 o'clock tomorrow.
Yes, I'm gonna rip them for, yes, at 11 o'clock, and I will show everyone.
My chat is surprisingly silent today. Write something.
I'm gonna give them to them for 11 o'clock tomorrow.
All right, okay. Anyone else?
About
Racy. Okay.
I'm just writing down
okay.
a banner here so everybody knows.
The state may not, I don't know what they're going to do, but I certainly want to keep the smile on the court, the prepared court. So this is what I flagged, but if this is not what the state is doing with this witness, they would just say that, then I could just move on. First thing is, It's July 15, 2015. Over objection, this honorable court is admitting a DeKalb County in custody statement to an ATF agent Cunningham and Detective Racy. Racy, I think is R-A-I-C-C-I. Oh, SS, not CC, not collect letter. SS. Samantha. I've asked for, I put in writing, I filed a motion, I could give you the date, but it was months ago. And I specified if, if the state's going to play it, obviously over objection, there are statements made about the search of Mr. Williams' home that has been suppressed.
I think we talked about that. Yeah, I suppressed those already.
Yes, but I'm again, I know, the happy court.
A forewarned court is a happy court.
Okay, thank you.
All right.
I'm trying to, I've raised this a long time ago. So the state hasn't given me any type of redaction. I've given them what I believe, but if I'm wrong, I'm not trying to waive anything. It's not my recording. So I would like that if the state's going to play it. If they're not playing it, I'm going to move on to the next issue.
So is this custodial statement less the statements or any statements made about the search of Mr. Williams' home? Is there going to be any other issues I need to take up?
No, Your Honor, there will be none. No.
Okay, so you've done the redaction?
So, Your Honor, two things. One, we don't know the court just denied the motion to suppress the statement. And we have.
I'd say that a long time ago.
Right, that's what I'm saying. Mr. Steele said that the court admitted over his objection. We're not saying that we're necessarily playing the statement, but if we did, it would be with all of those redactions. And of course, we would give to counsel the copy of it before we.
All right, let's just do that now so that there's not a problem, okay? Because look, it's better and for smooth of ease of presentation for them to have that redaction. And if there's any objection to the redaction, or is there something else that needs to be redacted, which sometimes happens, things are, omitted by accident, and that won't be a problem or an issue. So can we do that? Can you turn that over by tomorrow?
Yes.
Okay. All right. Okay. All right. Next.
Okay, so you ordered that all jail calls that the state intends to use at trial be given to us. We were given 2. But let me rephrase. We were given thousands of jail calls, but the state identified 2 that they shared with Solomon Court and us. So on those 2 that we already have, one of them has Miss Diop. That's D-I-O-P. It's her last name. She's speaking with Mr. Winfrey. I'm objecting based upon hearsay. She's not a witness. I don't know if she's going to be a witness, but she's non-testifying. And I'm objecting to that jail call for that portion. On that same jail call, there's also a relative. I don't know who it is. It's a relative of Mr. Winfrey. I'm objecting to that part also because she, as a woman, is not on that witness list to my knowledge. Now, look, I don't know who that person is. I just know that that person's not testifying, at least for the jail call. So I'm objecting under hearsay to these non-testifying people. There is the second jail call that we all heard, Your Honor, that was sent to you.
Oh yeah, it's Trinton says she 100% wanted to play it without a redaction and got busted. Yeah, because this is over and over again, despite the judge's order to certain things are out. They refuse to do any redactions until the defense says, Your Honor, we need to make sure this is done. And then the prosecution says, yes, we will make sure it is done. Because they have not done anything in doing any redactions until it's brought up here again. Because they are, I agree with Trinton. The prosecution definitely are planning to do some surprise crap. And why do I believe that? Because they always do. And the judge approve of it.
That involves Mr. Williams on the call. I'm going to object, but I understand that is Mr. Williams. So, I'm objecting just for the fact of 403. It's unnecessary, doesn't go to highlight anything. However, I understand the rule that I believe it's my client's voice and Mr. Winfrey's voice. So that portion I'm not objecting to in and of itself.
You just have a general objection to the phone call being admitted, period.
Yes.
Okay.
Then more specifically, any non-testifying party except my client.
Okay, right. But that's the one that involves Mr. Winfrey and your client purportedly, right?
Small part. Other parts involve other people. It's more than my client on the call. It's as if like.
So do you have objections to those non-testifying witnesses as well?
Yes, that's what
Okay,
I'm saying.
all right.
I'm objecting to all the non-testifying witnesses.
Okay, so let's do Winfrey call number one, State. What about these non-testifying?
Fred asks, what's your opinion of the judge's handling of the case? You must be new here. You must be here for the first time. Oh, I can describe it in one word. Fuck twat. Oh, I'm sorry, YouTube. It's my accent. I mean four-quad. It's the accent. I promise you. When I suddenly burst out in words, it sounds different, but it is the accent. I meant four-quad. Welcome to the welcome to the show, Fred. You're in for a treat. I know this is an insanely boring trial, but I have my ways to make it somewhat entertaining. Okay?
Witnesses that are you going to, Mr. Steele's purported, are they going to testify as part of your case in chief or the foundation for those calls, or what's your intent? Are you going to edit them out?
So, Your Honor, we're not, the calls that we'll be introducing, through Detective Racy, and it will be Ms. Hilton that will be doing the, examination. The calls that we will be introducing they come in through a number of exceptions, the statements that are not made by Defendant Williams.
See here how evasive she is. The judge asked, why is this evidence brought in through this witness? And she goes, the reason why we are doing this through this witness, well, we are using the exceptions that the statements are not made. Blah, blah. She's not saying why they're using Mr. What's his face? Shellface? I don't know. Shelley? I can't remember. I don't care, okay? Okay, I don't care who the cops' names are. Yeah, so through the detective, not a party to the call, they are introducing these calls because there are exceptions. Yeah, but it still has to be introduced through proper channels. But apparently not in Georgia, and apparently not in spineless Judge Glanville.
What about the non-speaking witnesses that are not, or non-testifying witnesses, not non-speaking, the non-testifying witnesses? Of course, Mr. Winfrey, his statements would be admissible as probably as a party opponent, but what about the other people that are there?
For context, Your Honor, under the rule of completeness, the conversation itself that is being had,
Still hearsay. Still hearsay.
it would be admissible to complete we're not using those for the truth of the matter asserted. They would be.
I know that, but yeah, I mean, but that's there's.
Here's my thing when they say there is an exception for the hearsay rule when it's not for the what's the word again? It's so stupid.
Truth of the matter asserted.
Truth for the matter asserted. It's not for the truth of the matter asserted. Well, then it's irrelevant. That is my opinion about that absolute garbage. If it's not for the truth of the matter asserted, then it is irrelevant. Then you need to lay the foundation for this cause, and you can only do that by having one of the parties in that call testifying, in my opinion. But I know, not in Georgia.
I know that, but yeah, I mean, but that's that they're still objectionable under that particular basis. So
If we could just
we've covered this before.
We have.
We've covered this before.
To pull up the calls themselves or to speak specifically about.
I listened to those calls. Remember, you gave them to me.
So, Your Honor, they are it could be considered co-conspirator statements that are being offered for the effect. So when you get a response.
And now, all of a sudden, it's for the effect. Also, one of these extremely vague exceptions to the hearsay rule. They are using everything. If that doesn't work, next thing. If that doesn't work, next thing. Here's the thing, which is in the judge's discretion. If they fail, he can simply say, well, my ruling is this, sit down. If you want me to change your mind, write a motion. But that is not admissible until you write a motion and we handle it down the line. That is in his discretion. Does he do that? No, because he is a part of the prosecution's team and he wants the conviction as much, if not even more, than soulless Miss Love.
Mr. Winfrey, to something being said. Mr. Winfrey, for instance, he asks someone to do something, to call someone. And the person responds, okay, whatever. And then Mr. Winfrey gives further instructions. Those statements, Your Honor, and I will pull up the statute before we give you 1 second to do so. Those statements are. So I'm going to pull up the statute.
Amanda Louise asks, are the people who took plea still considered party opponents? They are unindicted parties at this point. Well, they have taken plea deals. So, yeah, they are party opponents. I need to think about that. Good question. Thank you. I will store that, and in a break, I will try to give you a better answer.
So in this particular call that we're talking about, Judge, as it stands today, we're looking only to get in Mr. Winfrey's words and in response to the request that he is making, that he be put on paper so that the police don't think this is some street shit at the end. So not the whole call. That includes other commentary, but the portion where he is instructing someone to do something for him, and their response to his instruction. And the fact that he made the request, and the fact that the response was given, not so much what the response is or the content of the response, but just that, for instance, put me on paper with the wide sale so they don't think this is some street shit. Okay, we'll do that. Not saying that they actually did, but the fact that it was conveyed. So that portion of the first call.
You want to give me the statute?
Oh, yes.
And how long is that particular portion of the call, on call 1? Let's identify, what date and time was that call?
Yeah, this is a recap for you who don't know. So we don't. After a lot of back and forth, of course they're allowed to play it. Why? Because Judge Glanville is spineless. Let's move ahead to the next issue that is up here.
Benefit of that, you can make objections and I can make rulings on that. All right, sir?
Understood.
Okay. Anything else?
Yes. So the state's not really saying what they're using Detective Racy. If we're done, then I'm done. But if they're using Detective Racy for any type of cellular telephone expertise.
Okay, well, let's find that out. What about Detective Racy and cellular telephone expertise?
Your Honor, as a part of his investigation, he was the lead detective in this case. And as a part of his investigation, well, let me say, as a part of his training as a law enforcement officer, he has learned how to plot cell phones. The state does not intend to introduce him as an expert, but we do.
Here's an interesting thing. What the lead detective does is that he gets the information from the IT department or whatever they call it. He might have learned something about how it works, but I honestly do not believe this Detective Racy have any idea on how it actually works. That is why in cell phone and all of that data thing is, you need an actual expert. But somehow in Georgia, there is a statute that a cop who works with this within reason, because reason is not vague at all, can testify about very limited about this cell phone data thingy. But do you think that is what's going to happen when this detective Sealing cell phone? I can't remember his name, and I don't care about his name.
Do intend for him to talk about what he did in his investigation. As a part of his investigation, at least for one or two of the phone numbers, he did plot those phone numbers to see where certain phones. It's not an expertise because he can talk about.
Is there some case law that says that just distinguishes that issue? Because most of the time that I've heard testimony, the court has heard testimony about that. They've been qualified as an expert because it's outside the kin to the average person. I can't plot a telephone call, and I don't have specific knowledge about the carriers and directional issues and the like. So,
but he's been to training, Your Honor, which he can talk about the training that he's been to. He can talk about how he's been trained, and he can talk about what he did. Now, he will not go into as much detail as the azimuth and the three sides of the tower, but he can say, I went to courses, I know how to read the CDRs, and with that understanding, this is what I did. I then turned that information over to the experts to confirm what I did. But
bull crap. Bull crap. Out from that machine spouts, here's the information. He can read it. Okay, that is about what it says. And then he hands over to the IT department who translates it. They then hand it over to an expert when it is time for trial. But not in Georgia, apparently.
he specifically knows he's been in training. He's read the plots. He knows how to read CDRs. And what he did was he went into, I think he's going to say, I went into Google, I put up the longitude and the latitude, and I plotted it. But he's not going to talk about the azimuth and the size of the towers. He's just going to be able to say, this phone was at this location based.
That would be bolstering. So if he goes up and talk about, well, I plotted, the phone was somewhere over there and the tower was somewhere over there, and then the expert comes up and say, is that correct? Yeah, that's bolstering, and it's not allowed, should not be allowed. Well, we'll see what
on the longitude and latitude at this time, and this time. But he's not going to go into the full detail as our expert, Mr. Burney, will later on, because it's two different type of analysis. But what he did do is obtain cell phone records. He's had training on how to read those cell phone records, and he did plot the information based upon his understanding of reading the records. And he will talk about that training before the jury, so that the jury knows he's able to do it, and the foundation will be set that he's able to talk about it. But the state does not intend to go into more of the scientific aspect of towers with Detective Racy.
He has received 5 different specialized trainings in.
Items. First, I'd like to inquire if the court allows, whose 2 jail phones are we talking about, records are we talking about?
Whose cell phone records is he going to talk about?
Offhand, Your Honor, I know the one ends in 8556. And there's a few that he pilot, but I can say for sure.
These are the 2.
Excuse me, 8553.
8553.
Remember
yes,
that.
The number ending in 8553, okay, as well as the number ending in 3383. Those are 2 for sure that I know that he actually, like I said, figured out the longitude and latitude and put that in like a Google.
Okay.
Based on his understanding of reading the records and his training, and he had done it multiple times prior to this particular incident. And this is all in his report that he talks about, that he plotted these prior to giving them over to the data analyst. But in his report, he talks about him plotting these phones himself.
Oh, do we finally get to see a report, or is that last too? Okay, a little. YouTube allows me to gift 10 free memberships each month. I handed out 5 on Saturday, and here's 5 more. Dun dun dun. And I went to Hermes Hollywood, Tabitha Gifford, Lindsay, Mary Cox, and Robert Harris Jr. Congratulations, you now have access to all my members only content, which is more personal things. It's the form, bit about my work, personal thoughts and stuff like that in there. And you also have access to my Discord, where you can debate and discuss the other cases and this case that I follow. Okay. Congratulations. Now, if you want to be gifted memberships too, press that on the top of the chat there. You can see some present thingy. If you press that, you should get the option of allowing to be gifted memberships or something of the sort. Let's skip ahead.
Former county jail officer improper.
Oh, sorry.
490, 316 Georgia, 490, Moody versus the state. And my concern is, or the court's concern is, that it does fall into the category of expert testimony because it is based upon scientific, technical, or other specialized knowledge. So if you have some case, because this is what it says right in this particular case, Moody, you had Moody contends the prosecutor committed misconduct by listening from 2 Fulton County jail nurses and a former county jail officer improper medical opinion testimony designed to rebut his expert testimony. This is under OCGA 24-7, 701 alpha, through 701A. A lay witness may testify in the form of opinions or inferences that are rational based on the witness's perception, helpful to a clear understanding of the determination of fact and issue, and not based on scientific, technical, or other specialized knowledge. So lay witnesses may draw on their professional experiences to guide their opinions without necessarily being treated as expert witnesses. But in the cell phone folks, that's technical or other specialized knowledge. And I mean, if you qualify for an expert, that's fine. I don't have an issue. Or you've got another case which specifically says, hey, folks testifying about cell phone records or plotting. This isn't the first time this kind of evidence is being elicited for, in trial.
Why is Judge Glanville asking them to find other case law? His job is to, okay, this is the case law. Then, if the prosecution wants to challenge it, write a fucking motion. And it will be handled at a proper date. Now, he's telling them, please search for one. Please, pretty please search for one. I really, really want to judge in your favor. Please. Jesus freaking Christ.
So if you got some other appellate opinion that would be informative to the court, I'll listen to it. But it looks like under Moody, citing Bullard versus the state 307 Georgia 482 at pinpoint 491, it would look like that it would fall under scientific, technical, or specialized knowledge.
Thank you, Your Honor. If we could have these next couple of days to look about some case law.
That's fine. And I'm saying if that does fall within that category, you could certainly qualify him as an expert, lay the foundation, attempt to qualify him as an expert, and the court will consider that accordingly. Yes, Mr. Sharp.
Thank you, Your Honor. One additional concern that I had about Racy, Detective Racy's testimony. As part of this case, we were given ballistic reports, gunshot residue reports, other sorts of reports. Now, the state has not indicated that they're seeking to admit any of this scientific evidence through Racy. But if they are, similarly to how Mr. Steele just addressed the cell phone data, I'm going to be objecting to that. I think it falls under the case that you just cited, but also, Your Honor, it's a confrontation clause issue. And it falls under Bullcoming v. New Mexico, 564 U.S. 647, that's 2011. And that case basically said that scientific expert, you can't just call in another scientific expert who had nothing to do with the testing of the materials. And certainly under that reasoning, you can't just ask the lead detective what the results of some scientific tests were without bringing in the actual scientists who performed the test.
Well, without laying foundation as to that, because sometimes that evidence gets admitted independently and then it forms the foundation, because once it's the expert test or the technician testifies about that, say for example, it's ballistics or whatever else,
Well,
then of course you can testify about
and
that.
I don't know of the state planning to call any of these experts, so I'm just going to just say that I'm going to have an issue if they attempt to
And
get into any of these scientific.
that'd be foundation, and you can certainly.
Hi, Gwendolyn. Welcome.
Was that?
That would be foundation. You could check. You could certainly object accordingly. Okay.
I just wanted to flag that for Your Honor.
All right. Okay. Anything else, Mr. Steele?
Your Honor, and again, I don't know. Again, I don't know if this is an issue, but if the state tries to seek the admission of Mr. Winfrey's certified copy of his guilty plea in Cobb County through this witness, I have concerns, especially with this, because as the court already ordered, but I did not see it, the state is ordered to redact and let us review and then present to the honorable court Mr. Williams' name from the indictment. I would ask the indictment not go back. And again,
Well, we deal with that later. But has the redaction occurred?
not to my knowledge.
Your Honor, there was,
I'm sorry.
Your Honor, there are two things that I needed to point out to the court. One, the line of questioning of Mr. Lewis by Mr. Adams related completely as to why it is that Mr. Lewis would be suing Jeffrey Williams and YSL when neither of them, or at least not Mr. Williams, was alleged to have been anywhere. So by asking those kind of questions, I know that we approached the bench at some point.
And I still have not.
So, right, so we let Mr. Lewis, we didn't ask anything about that. But in terms of the Mr. Williams' name being listed in the indictment, the court has ordered until the court hears further argument or further elucidation on the point that we do certain redactions. We are not intending to put up anything in front of this jury without putting it in front of the court first and letting it be known. So even if we tender a copy of Mr. Winfrey's certified conviction, we would not be publishing that conviction for the jury with anything on it that the court has told us to redact, period.
We've covered that already, yes. So it goes without saying. But there's not.
The judge's exact question, have you done those redactions? And Ms. Love clearly says, no, they have not. Again, as we spoke about 25 minutes ago, they don't do it until the very last minute. And if the defense doesn't bring it up every time, they will probably try to do it anyway. Because they have had the judge change his mind about his rulings before. So of course they will.
Not going to be any testimony about Mr. Williams, right? From Cobb County?
No,
Okay.
no, it would not, wait, to be clear, when you say from Cobb County.
Cobb County, yes.
Ms. Hilton is, she's pulling my coattail, but Your Honor, the point that I'm making is we won't be referencing his name in that indictment.
Okay.
With this witness.
All right.
That's what I mean.
There
when
may
I
be
say
other
that.
reasons and other
Yes,
independent bases
yes,
that may be relevant and admissible, but I'll take that up. I'll cross that bridge when I get to it.
And then
Or isn't it?
the informed court is the happy court. I don't know, it started out at the bench where I said it would be best if the state can outline their topics with this witness so we can target it, because when that didn't happen last time, I didn't realize that the state was going to play a certain exhibit, and then the court, got upset and said, why didn't you raise this beforehand? So that's the issue.
That was different. That was different because you raised that on a Friday. And again, we took it up. We didn't take it up because, Mr. Steele, you are a very esteemed advocate, but had you mentioned something Monday morning, say, hey, I sent you an email over the weekend. You see that? And it says this, and we really need to take that up before our witness goes on the stand. That was that issue. So I'm I'm just asking you if there's anything else that we need to take up. Certainly, I'll consider it, but it just needs to be timely.
If it was
That's all.
eyewitness, I could tell you exactly, but the state's not giving the roadmap. So those, I'm just trying to tell you that those are the items that I have targeted.
Okay, but what's the fourth? Okay, in terms of this fourth thing, what do you believe that the state is going to get into that? I mean, because all of you, this is not your first rodeo. Is there any other area you believe the state, just like you've been doing right now, you believe the state's going to get into that you need to ask me about?
I don't know. I think I raised everything, I guess.
Okay, all right. So you got, okay, I mean, I don't think that the state should be required to give you the roadmap of their examination. I wouldn't do that for you. I mean, but
yes, you would, because you would tell me if you can beat me, here you go.
well, that's me as an advocate, but but anyways, so we'll cover the jail calls on Monday. We'll cover the bait. The state will identify and flag those to you. I've heard the case of Cantwell already. So I need you all to hear them if there's any further objection. Number two is the
Yes, Judge.
the detective or officer raised these cell phone discussions without being qualified as an expert under Moody versus the state 316 Georgia 490. The state says they'll research that issue to see if that is proper for him to testify as a lay witness in that respect. Three is the Mr. Winfrey's certified copy, which has Mr. Williams' name redacted out of it, which if the state introduces it in terms of discussion, that will be the only thing that they don't talk about Mr. Williams in this particular document. I have said that Mr. Williams and maybe reference at another times, given the foundation, subject to a foundation, subject to other additional rulings. So, and then, so is there anything else, Mr. Steele, at this point?
And I know you were looking for another one. It was the July 15, 2015 in custody statement. That was when you
July 15, 2015 in custody statement.
Yes,
I think we covered that already. You indicated that there were references to Mr. Williams' search that I've excluded.
Right.
The state has said they've already redacted that, and I don't know whether or not they're going to use that particular statement.
No, Judge. They actually said the opposite. They have not done the redactions. They will, but they haven't done them yet.
Right. They did not, to my knowledge, share the redaction. I know they didn't share redaction with me, so I can't listen to it. But yes, they said they're not sure they're going to.
Did you all share the redaction with Mr. Steele
That's what I just talked about earlier, that I would give to him, the redacted copy.
by today or by tomorrow 11?
And that's what I said. He
Okay.
redacted that portion out and provided it to them by tomorrow.
Okay. All right.
Then because Detective Racy knows about the search of the home, the court can order the prosecution to remind.
That goes without saying. That would be improper because that. Yes. Yeah, just make sure you cover that with him because I don't want to hear that because I've said that like 4 or 5 times already about excluding that particular search. Okay, the one on July 15th, 2015. All right. Okay. Just make sure witnesses get sometimes run afoul. So please, before he comes on the stand, we need to let him know, hey, anything about the search of Mr. Williams' home. Okay.
Okay, that was that day. Let's jump up to. Hey, let's jump up to yesterday. Yesterday started. See here, in the middle of everything, in the middle of an argument. And I have to do a swoop. Where's my swoop? Where's my swoop? Here's my swoop. My Norwegian fire-farting dragon. All right. Let's see what yesterday had. Yesterday was a long-ass day. But there was a good chunk of pauses as well. So let's just dive into it.
All right. Good morning, Ms. Hilton, Mr. Helsky, and Ms. Atkins. All right.
And let's listen about those jail calls.
Our jurors out. Let me just kind of cross off my to-do list from last week. 4 things. Did you all resolve or get the portions that you were going to play, the 3 portions from the calls on 28th June of 2015 and June 13th of 2015?
Yes, Your Honor, we provided on Thursday at approximately 11 a.m. The times that the state intended to introduce with the jail calls. There were 7 jail calls total, 2 that the court and defense counsel had previously heard, and then we added 5 additional jail calls and provided the relevant timestamps for those.
Okay. All right. Okay, we covered the admissibility issues on that already. Number 2 was the issue of the expert witness issue or lay witness issue. You anticipate that Detective Racy is going to testify. The court is of the opinion that in order for him to testify about some of the things you wish him to testify to, he would have to be qualified as an expert. The court relied on Moody versus the state, 316 Georgia at 490. Did you come up with anything who specifically says that that is not of expert testimony?
Yes, Your Honor, we did.
Of course you did.
First,
Let me have the case law.
so I have a couple of things, Your Honor. Well, the case law, the 11th Circuit case that I rely on will be United States versus Feliciano, which is FELICIANO, which is 300 Fed APPX 795.
Spell it for me one more time. See if I can pull it.
Feliciano, FELICI.
One second.
Adrian Love has been a prosecutor for the past decade, I think.
ICI.
I don't know what he did before that.
Sure, 300 Fed period APPX period 795. And it's going to be,
Is it Feliciano Francisco? When was it decided?
this was a 2008 opinion, Your Honor.
2001?
8. And his name was Jimmy Feliciano.
Now, I wonder what kind of layman expert testimony that was, because if it wasn't about cell tower thingy, it doesn't apply. It shouldn't apply. Often circuit appellate court and state what's it called and state supreme courts are very specific in their rulings. For instance, if it was a nurse who testified about a medical procedure that normally just doctors do, or in this case, is it a cop who testifies about something that normally an expert in cell tower things normally does. There's a 2010 case. Don't see it with okay.
I think you have the wrong spelling. One more time for the spelling on the last name.
Sure, it's 300.
No, last name.
Oh, FELICIANO.
They are talking about that's Armando Feliciano from 2010. Is it a US case? Okay. There you have it. US versus Feliciano. Let's see here. Oh, it is holding that a police officer's testimony regarding locations of cell towers was based upon officers' review of cellular telephone records and did not constitute expert testimony. Okay. Here it is. Let me skim through it. So, okay, yeah. So it is applicable, but here's the thing: state Supreme Court. Now the judge is in his discretion to adapt a U.S. Federal court case. But I'm not entirely, I don't think they have to, because normally you just use within state until the state appeals court or the state Supreme Court says it's okay to use this, as they quote it into a new decision that makes it applicable within that state.
Okay, one more time for citation. I think I have the correct spelling from Seattle. What's the citation?
Sure, 300,
300.
Fed,
Fed.
APX, APPX, 795.
Let's skip ahead.
And so it's probably at the top of, it's the bottom of page 800 or pen site 800, near pen site 801.
That is okay. I found it. Let's see here. If I can make it. Where is it? There. Third, we are unpersuaded that the district court abused its discretion in allowing Detective Christie to testify about cell tower sites, which hindered Feliciano's argument that Manny Ortega was the sixth participant in the robbery. Okay, but here's the thing. Detective Christie testifying about cell tower sites are different from what the prosecution wants to use Detective, I don't care about his name. That's not what he's going to testify about. He's going to testify about plotting, not cell tower sites. So it is not, even if it's applicable somewhat, I do believe the Georgia state statute is more on point. But it's this court with Judge Glanville, who is always looking for a way to allow the prosecution to get something in.
Okay. All right.
So, Your Honor, here in the Feliciano case, the court is clear there's a distinguishing factor between what needs expert testimony and what does not. And what it says here, and I'll read this portion of the opinion. The court says, third, we are unpersuaded that the district court abuses discretion in allowing Detective Christie to testify about cell tower sites, which hinder Feliciano's argument that Manny Ortega, not Feliciano, was the sixth participant in the robbery. If the witness does not testify as an expert, the witness's testimony in the form of opinions or inferences is limited to those opinions or inferences which are A, rationally based on the perception of the witness, B, helpful to clear an understanding of the witness's testimony or the determination of a fact and issue, and not based on scientific, technical, or other specialized knowledge within the scope of 702.
Here's the difference. I can't see when I skim through that the state in that case had a cell tower expert. Now I'm just skimming through it because here the prosecution have access to an actual cell, the expert. So yeah, I'm not persuaded.
The line between the expert testimony under Federal Rules of Evidence 702 and lay opinion testimony under Federal Rules of Evidence 701 is not easy to draw. Thus, a law enforcement officer may be qualified to provide both lay opinion and expert testimony. Federal Rules of Evidence 701 Advisory Committee's note citing U.S. v. Figueroa with their citation. In fact, we have recognized that police officers can testify as lay witnesses based upon their particularized knowledge garnered from years of experience within the field. Similarly, other courts have held that experience-derived police testimony concerning criminals' typical modus operandi during a drug transaction does not automatically constitute expert testimony, but lay witness testimony admissible under Federal Rules of Evidence 701. Here, the purpose of Detective Christie's cross-examination testimony concerning the location of cellular towers simply was to establish that Manny Ortega's cellular telephone calls to Ortega following Ortega's arrest did not originate at a point near the arrest location. Detective Christie did not express an expert opinion based on scientific, technical, or otherwise specialized knowledge as required under Federal Rules of Evidence 702. Instead, he simply reviewed the cellular telephone records and the summary of those calls, which identify cellular towers for each call, and based on his personal knowledge concerning the locations of certain cellular towers, testified at the time of the call, Manny Ortega's cellular telephone was nowhere near the arrest location. And Your Honor, this is what distinguishes what Detective Racy, what the state intends with Detective Racy's testimony from Agent Bernie, James Bernie, who was the expert that we qualified. The state does not intend to ask Investigator Racy how cellular phone towers work, what's the distance between them, but simply for what he read and interpreted from the record, where did he determine the location to be? Your Honor, I also want to direct the court to Carlson's on evidence, specifically page 361, that talks specifically about cell tower mapping. And here, Carlson advises or writes, the mapping of cellular telephone calls has been held to bypass the need for expert testimony. Along these lines, Rule 701 authorized the Metro PCS records custodian to explain how cell phone tower records pings from each cell phone number and how he mapped the cell phone tower locations for each phone shown in company records. Similarly, testimony concerning telephone records, abbreviations contained therein, as well as the location of the defendant based upon a map of cell tower locations, did not require expert testimony. Henderson distinguished between testimony about how cell towers operate, which would require expert testimony, and testimony concerning the cell phone records itself, which would not. And so again, Your Honor, Detective Racy, our intent is only for him to testify as to where particular phones were at the time based upon his reading and understanding of the records. He will testify about how he has been trained on reading cell phone records. He has plotted numerous cell phone records prior to having to plot the certain phone calls in this instance, Your Honor, and that is the extent of what his testimony would be. You will see that distinguished from Agent Bernie later on, where Agent Bernie will go into a more scientific analysis about cell phones and how they operate. And so, Your Honor, with that, we don't believe we need to qualify Mr. He's an agent now as well himself, Agent Racy, as a expert solely for what his testimony, we will get from his testimony right now.
All right. Mr. Steele, anything further, sir?
Yes, sir.
Okay.
Your Honor, and good morning, sir.
Good morning.
To everyone, as always. Your Honor, United States versus Feliciano is a unreported opinion of the 11th Circuit from year 2008. And specifically in that case has been held for and highlighted for the fact that Detective Christie, which is CHRISTIE, simply reviewed, I'm quoting, simply reviewed the cellular telephone records. They were in evidence as cellular telephone records, and a summary of those calls, which was in evidence, which identified cellular towers for each call. So it didn't take much to say it used this tower and this tower is here from the records. And then based upon Detective Christie's personal knowledge concerning locations of certain cellular towers, he testified that at the time of the call, Manny Ortega, Manny's MANNYORTEGA, Osvia's cellular telephone was nowhere near the arrest location. Here, it is my understanding that the records have to be interpreted. They don't spell out where the cell towers are. The Honorable Bruce Harvey afforded us another case, this honorable court to look at, which is United States versus Natal, N-A-T-A-L. Your Honor, it is 849 F3rd 530.
This I love
His, Second Circuit
I,
appeals
I
case
love these discussions
17.
because
And it
this is
specifically states that
very high
N.Starow
lawyering, even from the prosecution.
uses cellular phone records
I,
and cell tower locations
I enjoy this
determined
more
through
than
some range of error
most people
to
do
sell
because,
phones,
hi, for you
location
who are
and
completely
genuine
new
time.
here,
Cell-
let's pause here. Hi, for you who are completely new here, hello, I'm Nick. I do labor law, and I do it in Sweden. I've been doing it for over 30 years. I have a law degree. I'm trained in evidence evaluation, witness evaluation, negotiations, mitigations, all of that stuff. So this is kind of in my wheelhouse. So I'm having a great time with this, but for the wrong reasons. For me, it's more technical to listen to them argue about how to interpret a certain statute. I hope you enjoy it somewhat, but I'm loving this. Oh, yeah. Sylvia Edwards. Head on the nail. He should bring in Fanny's statement that cell tower information is not accurate. Yeah. For you, if you missed out on the Fanny Willis disqualification case, in there she claimed that cell tower information is not accurate. That is because she claimed that Nathan Wade, even though his phone pinged near her apartment, he was never there. So the district attorney, said in motions to court that cell tower information is not reliable.
Cell phone connects to a cell phone tower in order to assess the cellular network and communicate with other phones. Each cell tower covers a particular geographic area, which depends upon a number of the antennas operating on the cell site. While the proximity of the user is a significant factor in determining the cell tower with which the cell phone connects, other factors also play a role, including structural features of the tower, the phone, as well as the geography and the topography of surrounding environments, and all this requires expert testimony.
That's location, you're talking about location, how cell towers operate?
The location of the cell phone hitting off a tower. If it's in the record and the record comes in, and a person like yourself can just, or me, can just read the record and say, here it is, and it says it right here in the record, I don't object. And that's what the United States versus Feliciano states. But what the state is going to do is extrapolate. As I told you, they're going to use Agent Bernie's information through Detective Racy, or Agent Racy now, and have him testify to location data, and then come in later, I guess, over objection, and now try to bolster that testimony or make it cumulative. And I'm not so sure that Agent Bernie even did this analysis that Detective, in fact, we were never given it, that Detective Racy is talking about. So it is really fresh testimony, that's expert testimony. I would object to saying.
What's Racy going to testify? You all told me Thursday is cell phone records and what plotting?
Yes, Your Honor, and may I respond to Mr. Steele? So.
Give me 1 second. Hold on.
Sure.
Okay, it looks like they're mapping a cell phone, telephone calls doesn't require expert testimony.
Ta-da!
United States versus Baker covers that 496 Fed, APPX 201. And it cites Feliciano as well. Also,
Yeah. And by the way, folks,
it looks like testimony concerning cell phone
there
records,
is
abbreviations.
168 of you, and less than a third of you have pressed the thumbs up. Seriously, folks, you have been on YouTube before. You know how much that means to us. So get down there, press the thumbs up.
Locations of the defendant based on a map of cell phone tower locations doesn't require expert testimony. And that's Henderson, 564F APPX 352, 10th Circuit, 2014. But it does say that Henderson distinguishes between expert testimony about how cell towers operate, which would require expert testimony, and testimony regarding cell phone records would not. So
In a ruling a couple of months ago, or in a hearing a couple of months ago, the defense argued from other circuits, and the judge more or less said, well, that is not our circuit. Now he himself is going out of the 11th circuit to find the reasons to allow in for the prosecution. This is the unfairness spoken out loud in this trial. This judge, he will give the prosecution everything. But once the defense tries, he's trying to burn them alive. That is the bias of this judge.
So, what else, madam?
Those are the two cases I was going to direct the court's attention to, that this is distinguishable, and I'm not sure if I wasn't clear.
And then they go on and on and on and on and on. So let's skip ahead and see who this agent is.
Presentation of the state's case, okay? All right, call your next witness.
Thank you, Your Honor. The state calls Agent David Racy.
All right, summon Agent Racy, please. Agent Racy, good morning, sir. If you would please approach the witness stand. Once you get there, if you'd be so kind to turn and face Deputy Hammond, be sworn as a witness before you sit down.
Yes, sir. You may be seated. Can you state your first and last name? Spell the both, please.
Yes, my name is David Racy, David Raissi.
Hey, good morning, Agent Racy. How are you?
Doing well, thank you.
Where are you currently employed?
I'm currently employed at the Bureau of Alcohol, Tobacco, Firearms, and Explosives, commonly referred to as the ATF.
And how long have you been with the ATF?
About
ATF is the agency that tries to ban your guns and doesn't allow you to smoke, who wants to ban cigars.
4 years now. June 2020 is when I joined the agency.
And what do you do for the ATF?
I'm a special agent in a criminal enforcement group, meaning just enforcing the federal criminal laws that we have jurisdiction over as ATF.
And prior to work with the ATF, were you employed?
Prior to ATF, I was employed by the Cobb County Police Department here in Georgia,
And how long were you with the Cobb County Police Department?
approximately 12 and a half years.
And if you could tell the jury, so when did you start your employment with Cobb County?
So October of 2007 is when I first got hired by Cobb County.
If you can tell the jury about your time with the Cobb County Police Department over the course of those 12 and a half years.
Yes. So first, when I got hired, I had to go through our police academy, and it's approximately 6 months long. After that, I graduated the academy and was assigned to what we call Precinct 2. It's basically Austell, Powder Springs, Mableton area of Cobb County, the southern part of Cobb County. I spent approximately 4 years on uniform patrol on the overnight shift, just a graveyard late night shift. And then from there, I transferred to the narcotics unit. We call it MCS, Narcotics Marietta Cobb Smyrna. It's a multi-jurisdictional county level narcotics unit in Cobb County. I was in an undercover capacity back then when I was younger, and spent about a year and 9 months there. And so that time frame was 2012 to 2014. In 2014, I was pulled.
Yeah, this is just background, and
I would just take on some of them the latitude and longitude that was provided there for that cell tower and put it simply into Google. There's other websites as well, like Radius Drawer, that you can drop it in, but you could simply put it in Google and hit go, enter, and then it'll take you the latitude and longitude. And so you get basically Google would show you where that cell tower was.
And I know we've been using the term plotting. What is plotting?
So that's just taking that data and again, putting it like on a map, utilizing Google or utilizing one of those systems like Radius Drawer or one of those computer programs. And then it would just basically place like pin drops. Like if you had a cell phone and you just dropped a pin, basically placing pins on the map, and plotting is just kind of placing those pins.
Now, you talked about the data analysts that were hired at Cobb County. Did you always utilize their services?
Yeah, we would. So I would basically do a rough plot it myself, and then I would formally send off either email or drop a disk off to one of the crime analysts and have them utilize one of the systems like CellHawk or PLX PinLink or whatever provider we had at that time. They would basically dump the data, drop it into that system and let the system process it for more formal. plotting or drawing, but I would also do it myself.
And when you were at Cobb County as a violent crimes unit, did you work a particular shift?
Yes.
What was it?
So initially I worked the evening shift. So the afternoon hours from about 1:32 till about 10 or 11 at night. Our hours changed later on, but then at the latter part, I worked day shift, but during this investigation, I was working the evening shift.
Now, you also talked about you received training on social media. Tell the jury briefly about your training that you received with social media.
Very similar. So on the job training, right? We all have social media. We all know how to search things on Facebook or Instagram or one of the social media platforms. So on the job training, but then also.
Let's see if he has something interesting later on. Yeah. Then they talk about the same thing they talked about through 4 other witnesses. Photos of the bus. Photo of the bus. The same photos of the bus that other people have talked about for a good number of times.
All right. It would have been at your direction.
Yes.
Let's see where it
30
is.
and 131 and 132, I object to the envelopes. There's writing on the envelopes, if you could take that up. And then 132E, I don't believe there's been a chain of custody.
May I see him, please?
Yeah, that objected because some of the evidence the prosecution wants to bring in has no chain of custody at all. Untraceable. But ta freaking da.
Try not to cut over another seal. Cut it open as well.
Those are bullets that could have been brought in through a prior witness, but boom, 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 boom. Cumulative, cumulative, cumulative. Same questions, same evidence, but now they are actually showing the bullets. And then they talk and talk and talk. And then they look at some evidence.
Sure. You got that. I'm going to show you what's marked 60 to 133A, between 133 Echo, 133 Echo out.
Yeah. No Kurosan, hi. If you go to the picture of the broken glass from inside the judge, from the inside, the judge in a superior instance actually says it's cumulative after he overruled an objection cumulative a few seconds before. Yeah, I was trying to get to that. Let's see here. Where is it? Where is it?
I'll overrule the objection.
This is going to be another projectile strike, and this is the driver's rear mirror at like the driver's driving would be to the driver's left of that, the first bus, Alvin Lewis's bus.
And we're going to move to 82 and 83.
So I'm gonna overrule myself. I'm gonna sustain this objection. We have had testimony about this already, so
Okay.
we'll move on to something else.
Sure.
Yeah. So now it is cumulative after a bunch of photos. And they still go over it a few of those again. And then they go on a break, and then they come back from the break. Let's see if something interesting happens.
Mario. Can you text him, Mario?
Discussion about evidence.
Objection. So just for purpose of record.
Thank you, Your Honor. Once you received those cell phone records, did you review them?
I did.
And after you reviewed those records, did you find any information that assisted in your investigation?
Yes.
What information did you find that assisted in your investigation?
Remember the gang experts they had on? How they questioned them? It was more or less the prosecutor loved asking a bad question, which contained information. The defense objected because of leading. Then she rephrased the questions, and the gang expert just told the same information back, and that was okay, according. Because those two gang experts must be two of the absolute most stupid people I've ever seen in a courtroom. By far. It was unbelievably stupid. Now, the guy whose name I don't care to remember had a bachelor's degree in criminal justice. And he still only got a job in Atlanta as a basic cop. There are people out there with bachelors in criminal justice who become expert witnesses, who become, high-ranking officers within the police academy. But that absolute moron couldn't, more or less, had to be thrown between departments until he got to the gang unit. So apparently that university degree is worth absolute nothing.
Ingoing, outgoing calls and location information as well, location history.
All right, so let's first talk about the location history. Did you, when we talk about the location history, are you referencing plotting the calls?
That's correct.
And did you plot the calls yourself initially?
Yes.
And after you plotted the calls, did you give it to your analyst, as you talked about earlier, to plot as well?
Yes.
I stand objection.
Specifically as it relates to these calls, did your analyst plot these specific calls in addition to you?
Yes.
Oh, that's Mr. Steele leading. Yeah, and I'm gonna overrule the objection.
After your analyst specifically plotted these calls, did you have to amend anything that you did initially when you plotted the calls?
No.
Yep. Calls are getting in, and he can testify about. And then, then she starts to write on paper. Jesus Christ. You can do this in a much easier way and a better way than writing on a damn whiteboard. And I don't know about you, but I get this feeling about this testimony. Yeah. Jesus Christ.
2920?
That's correct. So it's kind of like the credit providers, like.
And it goes on And then they look at some other evidence. And then look at what the fuck? This is and then they took a lunch break. See here.
Okay. All right. Where's our witness? Okay. Do I need to excuse our witness?
Yes, please.
Okay. All right.
And Your Honor, very quickly, the state at some point, either later this afternoon, depending on how fast the questioning goes, or tomorrow morning, the state intends to introduce two things that I just want to bring to the court's attention, just to see if there's any objections so we can deal with it. The first thing is a video. It's a social media video that Detective Racy pulled. This video was provided back on April 12th as a part of the pool of evidence that we intended to introduce during this case, during this particular act. The video specifically, the relevant portion that the state intends to get into is a video of Mr. Winfrey.
Remember the recap we did on the final day last week? Where was this video? The judge explicitly told them, is there anything else you will try to get introduced? No, absolutely not. And here they are, right after lunch on Monday. Oh, by the way, Judge, we want the video in. Jesus Christ, Judge.
Free at the gun range shooting what appears to be an AR assault rifle. We have not heard any objections to that video, but I wanted to bring to the court's attention that we do plan on getting into that video. The entire video was about maybe.
That video, by the way, is at a shooting range.
3 minutes, but it is it has third-party commentary, so we redacted the third-party commentary and solely focused on Mr. Winfrey at the shooting range. So that's the first item that I wanted to bring to the court's attention.
He is at a shooting range shooting a rifle. They want that in because it would make the defendant look bad. That's not allowed.
Okay, and when was the video purportedly made?
The video was made, well, let me say, prior to Detective Racy pulling it. So in 2015, at some point, we would need to go back to the complex video to see when it was pulled. But the video that Detective Racy pulled was the commentary talked about the ongoing beef or feud that was happening between Lil Wayne and YSL. And specifically, this video was created after Mr. Winfrey was arrested.
Okay, what's the relevancy of the Mr. Winfrey's range video?
Because he's the one to allegedly have shot up this bus in this case. And so it shows him at the range shooting a weapon that we believe to be what was used in this instance. As the testimony or the evidence provided that Detective Finney saw this type of weapon inside of his vehicle prior to.
Detective Winnie saw inside a vehicle the butt end of what he claimed was an assault rifle. Do you know, first of all, there's no such thing as an assault rifle, but number two, how many different kinds of rifles there are? There is no absolutely zero evidence that that gun on that range was even his.
On the night of prior to the shooting. And so it also shows, and we believe in the background of this video, you can hear someone that we believe to be Mr. Williams encouraging Mr. Winfrey to shoot the weapon at the range. And so one, it would show association. Two, would show that he knew how to shoot and fire that weapon And 3, it was a type of weapon that he was seen with on the night of. And also, and I'm not sure if this is gonna come up on cross or not, when this case was first investigated, there was some allegations that Mr. Winfrey.
I know. Here's the thing. That should never have been allowed because a guy at the shooting range does not equal anything. It's highly prejudicial. Has no probative value because it is somebody at a controlled place, a shooting range, firing a rifle that may or may not be a lone weapon. It might be from the range. I mean, anything. And they pull it off social media with no foundation on about a date or when it was even when the recording was from or anything.
Did not have the ability to shoot a weapon. And so this video contradicted that assertion that Mr. Winfrey could not shoot a gun in that capacity. And so for all of those reasons, Your Honor, we believe that this video is relevant.
I don't remember him saying he barely knows how to
And
fire
then
a
I'll address the
rifle.
second matter after that.
Good afternoon, everyone. Your Honor, over my objection, I believe that you are admitting Mr. Winfrey's guilty plea.
Redacted.
Over my objection.
Yes.
you're admitting it, and then yes, you did agree that has to be redacted.
Yes.
But, if you pled guilty to this incident, you need a picture of him at a shooting range to prove that he can fire a weapon. That's 1. 2, to my knowledge, in your trial, I never heard anyone make an allegation he couldn't fire a weapon. I don't know how that's relevant to our trial, your trial that we conducted. And then, I want to address, unless I misheard, the audio would be muted, but I heard Ms. Hilton then say that possibly Mr. Williams is heard in the background encouraging, but if the audio is muted, there's no reason, you let it in over objection. There's no reason to address that, but if I'm wrong, I do have voices. So anyway, those are my objections. It's not relevant. 403, it's a waste of time. I know that's not kind of, you didn't like how I said that earlier, but that's what the 403 says. It's a waste of time.
Hey, Diogo.
Would strongly object to any type of hearsay statements when I don't know who's in the background and about the beat that I can't cross examine. But I believe that that's,
All right.
Hearing from my colleagues that maybe last week, this particular video was discussed and maybe Mr. Steele spoke of his client being in the background, but I think it'd be easier for the court to play it as a short couple of seconds to play so that you can hear what's going on in the background. And then I think I can move from that point around.
Sir.
Thank you, Judge. Carson Matthews on behalf of Mr. Marquette, we would object, and I would object to this video coming in. We believe that under 403, that it's highly prejudicial. And again, look at 403 and that balancing test. I think the cases have basically stated that bringing in highly prejudicial material for any scant probative value gets us to the 403 prejudice. We're likely to hear a violent weapon being fired at a gun range. It's going to be loud, it's going to be repetitive, and I just believe that is prejudicial in itself to the extent that whatever scant probative value that it may bring would not lead us to it being so probative that it would outweigh the prejudicial impact they would have on Mr. Huey sitting here in this trial. And the rest of the defendants who it does not pertain to.
All right, what's it going to be marked as?
This is going to be 172 Echo, Your Honor.
All right, let me see it.
Go red. Let it rip.
Let it rip, and he shoots at a target. This has nothing but prejudicial effect. Nothing. Nobody made claims that he couldn't fire a gun. Nobody made that claim. But here we are. And
Mr. Winfrey has a very similar hairstyle. We know this video.
And
This was posted on April
Instagram
20th,
photos.
2015. So the state went further that this video came in or around maybe early 2015 or 2014. We don't believe that this was years prior to this video being placed on the internet.
Kimberly M says this case is causing delays in other cases in Fulton County. The next week, no court. Yeah, I've said this a bunch of times now, and I will repeat myself. Every damn day, this trial is allowed to go on. Between 4 and 8 cases are not. They could have handled 4 to 8 cases in this courtroom every single trial day, instead of this sham of a RICO trial. In 200 trial days, that is between 800 and 1,600 cases that will not get to court. Sorry. That is between 800 and 1,600 victims who will not get their day in court. That is between 800 and 1,600 defendants who will not get their day in court. Meanwhile, Fulton County Jail is overcrowded. People are dying in there. But Fannie Willis, up until a few months ago, her goal was to become the next Attorney General. This was just a stepping stone for her towards the Attorney General position. And she knew she wouldn't get there with home invasions, robberies, car thefts. She would get there through RICO trials. And here we are, with this absolute clusterf, this absolute scam of a trial. Meanwhile, real victims, real defendants will not get their day in court.
And again, this shows a connection between Mr. Winfrey, Mr. Williams. They having a good time. And it shows that, again, we believe that is Mr. Williams encouraging Mr. Winfrey to fire a gun at a gun range.
We don't know.
I mean, the voice, I mean, that would be up to, we have other pieces of information that's going to have Mr. Williams' voice, so that would be up to the jury to determine if those voices are similar, but we do believe that that is that voice. And it's my understanding that last week, Mr. Steele may have advised that this is his client in this video. Again, I don't know if I was present for that, but that this is his client in the video. This is his client's voice in the video. And they also last week, at least a line of questioning to Mr. Dennis was that the guns in the halftime video are fake. And so again, this is a showing not a fake gun, but a
Jesus Christ, you stupid. Of course it's a real gun. That doesn't mean it's that gun that is shown in that music video. It's a music video. They use props in music videos. This is a gun. It's Jesus fucking Christ. That is such a jump in logic that alone should render a bailiff tackle out of court. But we are in this court with spineless Judge Glanville.
real gun here. So again, them going down that line of questioning of in halftime, we don't know if it's a real AR or fake AR. Well, here is Mr. Winfrey with a real AR in a video. And so we believe that the jury should be able to see this evidence and then make a determination at that point.
I don't think so. Not with what I've heard so far. I think the defense's argument about a 403 problem is the court's concern, that it may be substantially more prejudicial than probative.
AR. Well, here is Mr. Winfrey.
If you open the door by examination or otherwise, either one of you counsels opens the door back up and makes this more relevant or makes it more probative than prejudicial, I will let the state revisit that.
Hey, Mr.
Oh, no, don't give me any. I don't want to hear it. I don't want to hear any of your test questions. Okay, I'm just telling you that if you open the door as to it during examination, I'm going to relook it again. So you can't have your cake and eat it too at this point. All right. Okay, all right, you know, yeah, you know what I meant. All right, okay. What else you have, madam?
And Your Honor, next, very quickly, the state intends on introducing the Instagram records of Jimmy Winfrey, but it's the Instagram of Pee Wee Roscoe. We also intend on introducing the Instagram of Jeffrey Williams or Thug 1 and the return that was received for Shannon Stillwell's Instagram. Specifically, though, as it relates to the Pee Wee Roscoe Instagram, the state has at this point 4 excerpts from that Instagram return that we would like to introduce to this witness. It'll be State's Exhibit 163, B, C, D, and E. I've shown it to defense counsel in order for them to review. And so I didn't know if there would be any objections to.
Can I see them, please?
Yes, you can.
You said 163 BC, Bravo, Charlie, Delta, and Echo?
Bob?
Is there an alpha?
No, alpha is the actual record itself.
Okay, so 163 alpha?
For the excerpts, it's going to be 163 Echo Bravo, 163 Echo Charlie, 163 Echo.
I need to figure out y'all's nomenclature.
Folks,
Okay, so it's
there's
163
over
Alpha.
180 of you
163
here.
Echo Bravo.
That means 100 of you, more than half, haven't put the thumbs up. I think I deserve a thumbs up. Not only because I do believe I do a good job at this, but also it's really important because YouTube algorithm, it's how many chats, how many of you speak, how many thumbs up or thumbs down, as long as you do something, being active. That is what the YouTube algorithm likes. So if you wouldn't mind, and it's free, please do. Thank you.
I'm not talking about that now. So for this discussion right now, we're going to talk about 163 Echo Bravo, 163 Echo Charlie, 163 Echo Delta, and 163 Echo Echo.
All right, let me see those, please.
Okay. And tiny break.
Okay, anyone have an objection to me?
This is my concern, and I don't believe it's coming.
Have you seen them, Mr. Sharp?
Well, I haven't seen the ones from my, they didn't have those printed out.
Why don't you take a look at them, or,
I don't believe those are the ones from my client,
They are not.
okay.
but
Mr. Steele, do you have,
I've seen them.
you've seen them? Do you want to go ahead and specifically object to them, or?
Yes.
Okay,
and
I'll come back to Mr. Sharp, okay? Or if you want to, you can come take a look at them so you can have a basis to talk with me.
Hey, there you are.
So,
Good work. Thank
go
you.
ahead, sir.
My objection is to the foundation again, just pulling it off the internet, all of a sudden becomes admissible for authenticity, 1, 2. There's writings on it. You'll see it. I think the word is text here on it, T-E-X-T, which is the writing on all of them. And I have nobody I can cross-examine, so I would like to object to any of the writing as well. I understand that they're from Instagram, is my understanding.
Whose Instagram page are they from?
Free, I believe.
And it's not just from the page around. I want to be clear. This is from the actual company itself.
Oh,
So
it's from
we sit-
Instagram itself. Did you get an authenticity or certificate that came along with this?
Yeah, so we have a business.
Do you have that?
Yes, Your Honor.
Subject to that, Mr. Steele, I'll probably objection.
And then I would like everything in, and then obviously go one by one. If both sides want to use it, we have to advise the court what we want to use, instead of just the 4 pictures, or 4 postings, I'm sorry.
Judge, doesn't this show you that the prosecution is fully capable of retrieving original data? And now for 5.5 months, you have allowed pictures from different sites, collages, and absolute Jesus Christ, Judge. If you know how to do this properly, then why haven't you done that for 5.5 months?
Sir, whatever, however you want to examine the witness is fine. I mean, but state's asking for those four. If there's a certificate as to all of them, that means that the authenticity has been satisfied. Do you have any other basis for an objection, or do you?
I didn't see any certificates, but I'm assuming that the state has it.
So we served it in this.
No, I'm not saying, I didn't get it. I didn't see it here.
Sure.
It's being pulled from the internet by Detective Race. That's how I understood.
All right.
No, I can show the certificate and then the CD that has the.
Now for this, they have every
Your Honor. I
piece
just
of
focus on the
background. So why, if they are fully capable of this, Judge, why did you hold them to a lower standard for 5.5 months? If they now show you they actually can do it?
Search, because that is what may or may not be objected to. So yes, the state has 163 Echo, which is the business record cert. We have 163A, which is the full Instagram record, and then these are going to be 4 excerpts from the record.
All right.
And my only other objection would be then.
And I'm sorry if I keep on saying it, 163 Echo is the exhibit with Echo Alpha, Bravo, Charlie, Delta, and Echo.
So 163 is a certificate. 163 Echo is the entirety of the record, and then you got excerpts marked Bravo, Charlie, Delta, and Echo. Correct?
One correction: 163 Echo is the certificate. 163 Echo Alpha is the full record.
Okay. All right.
And my objection goes to, if you rule on it, I'd like you to rule on, if you don't mind, I don't want to waive anything, is to the writings, again, it's hearsay.
The writing is the business record itself.
The text in the document, yes, sir, that's what I'm objecting to,
On what basis?
hearsay. Out of court statement, offered into evidence.
Are you offering any of the statements on the business record itself?
So, Your Honor, I'll first start with 163 Echo Bravo. And if you look, Your Honor, on the bottom page of 163 Echo Bravo.
Listen to this while I go visit the
PSA
the big boys room.
Came from zone 3.
I'll be right back.
Rounds, I'ma die. I'ma ride for them like a military mafia. You dig? You dig what I'm saying? Bankroll mafia, YSLRG. You dig, my little sisters. Your Honor, we believe the individuals in this exhibit. We believe for sure one is Ms. Dolly Greer. I think that's her.
Is who? I'm sorry.
Dolly Greer, or someone identified as Dolly Greer. The state believes the other individual, Mr. Aretha Greer, who there's testimony that those 2 individuals are the siblings of Mr. Williams.
Okay, but who are you going to get to authenticate the text? Because Mr. Steele's right. I mean, here's the thing: with a business record, you get your authenticity is satisfied. It is what it purports to be because you've gotten it directly from Instagram. It's still got objectionable hearsay in it that you need to have an exception for or some other basis. So, short of you, are you going to have anybody that is going to testify about this this text message, or do you have an exception to the hearsay rule?
Your Honor, Mr. Winfrey is a co-conspirator, both in the shooting that's being from April 26, 2015, as well as a co-conspirator in this in count 1 of this indictment, Your Honor.
So is this a text that he made?
This is a text that he posted when this.
That he posted?
Correct. This is the caption
Okay,
that he
all
would
right.
have posted when he posted this.
So you're saying it's a statement by a party opponent or party opponent?
And he would be a party opponent as well, Your Honor.
All right. I'm gonna overrule your objection, Mr. Steele. I will admit the 163 Echo Bravo over your objection, as well as Echo Charlie over your objection, Echo Delta over your objection, and Echo over your objection.
Nobody is surprised.
All right, Mr. Harvey, sir.
And I'm back.
105 again, and a motion for severance?
Certainly the motion for severance, yes.
Okay, all right, okay.
And a couple of other things. Motion for severance, number 1.
Okay, for you who wonder what motion for severance is Mr. Harvey represents, I also forget his name. He is mentioned once in 1 count, but he's there with everybody else. So Mr. Harvey argues it must be severed because everything that is brought in towards these guys is so incredibly prejudicial towards his defendant. But the judge does not agree. So this guy is risking life in prison for one count.
Number two, the fact that it's admissible as a statement of a party opponent means that it is just admissible against that person, not everybody else, and not Mr. Nichols.
But what if it's also admissible since it's a co-conspiracy, since they're charged in count one?
That's great. Remember at the beginning of this trial, the state was supposed to give us everything they were going to admit as an 801D2E statement. They gave us 3. This isn't one of them, and I would object to this being admitted as a co-conspirator's statement under 801D2E. I do not think it is in furtherance of any conspiracy, number one, and we weren't provided with this. We didn't litigate it before, and the whole purpose for you.
Okay, and assume you're correct. I would give that limiting instruction, but just not now. I would probably give it as part of the course instructions at the end, if it's appropriate.
Well, it certainly is appropriate.
I mean, because remember, you haven't presented any evidence at this point in time, and the law doesn't require it. In fact, you reserved your right to open and to present any evidence. So it's not even something I need to take up at this point in time.
Well, I disagree with you respectfully.
Of course.
Because it's being admitted under the state's theory against everybody here, even though it's a statement particularly.
Well, it's being admitted against Mr. Winfrey, and he's he's a conspirator.
But the jury doesn't know that. The jury doesn't know that it's being admitted against Mr. Winfrey because it's his statement as a party opponent, even though he is not here, or that it's just being admitted, if it is being admitted over objection, against Mr. Williams. And that's the purpose of a 105 instruction.
All right, ladies from the state, sir.
Your Honor, if instructions can be given to the court, that it can be given at the conclusion of when we give the instructions to the court at the appropriate, to the jury at the appropriate time.
All right. Mr. Harvey, I will overrule your request at this point in time for a limiting instruction at this point. But however, I will take it up and I will give you continue to give you a continuing objection as to that issue. Okay? All right. And I'm going to deny your motion for severance at this point in time. But I'll give you a continue your objections to that. All right, Mr. Chart.
Thank you, Your Honor. So my understanding is the state, through, I believe this witness is going to seek to admit my client, Shannon Stillwell's Instagram records as well. My concern, I don't believe that they have any specific pictures or anything or postings regarding this overt act, but they're going to seek to admit the records in totality. My concern, Your Honor, a couple of weeks ago, maybe a month ago, I was observing Court of Appeals, Federal Court of Appeals, and there's an 11th Circuit case, US v. Quentin Simmons, that's being considered right now. And the issue in that case is when records, in this case,
It hasn't been decided yet, right?
well, but
Just answer my question. Has it been decided yet? Okay, all right.
Okay, but the issue is when, whether it's records or surveillance tape, when it's admitted in totality, it's in evidence at that point. And even if we are just focusing on 1 or 2 pictures, say, of my client's Instagram photos, if we admit the records in totality, that puts it all in evidence, and that makes it all fair game for closing and fair game for arguments, whether those individual excerpts or pictures are prejudicial, whether they're relevant, and the like.
Well, I disagree with you. I respectfully disagree with you, sir, because just like these particular photos have writings on them, remember, it's just because a certificate just gives you admissibility of the records, or authentication of the records. They're still subject to other objections.
But there's going to come a time where the state's going to walk up with a thick pile of papers and say, we move to admit state whatever 153 EQZ into evidence, and then you're going to look at me as if I have an objection. And the problem is, if they're just being admitted in their totality, even if we know that the only thing that's been discussed is 1 or 2 things within those records as a whole are in evidence and become potentially fair game for argument later on. So if we're going to move to admit my client's Instagram records or anything else, I'm going to ask that we be specific about what we're admitting as opposed to just admitting the entire record. Because that's my concern. Once it's admitted to evidence,
Mr. Shard was the one has on numerous occasions throughout this trial called out the prosecution for doing shenanigans. And beside Mr. Steele, also alleged bias from the judge. So yeah, this is a judge who carries personal things and holds it against the attorneys. Why? Because that's just the way he is. He has no spine. He admits everything the prosecution, well, almost. Maybe 1 out of 1,200 pieces of evidence so far. He has ruled against 1, maybe 2.
in essence, and that's what the Simmons case is all about, is once it's in evidence, and it's subject to argument and things of that nature, even if it was never even discussed in the case.
Okay, but I have no visibility on Simmons. It was argued, so no opinion's been released, correct?
Well, it's my concern.
No, but I'm asking you, but there's no appellate opinion from, it's an 11th Circuit case?
Right, the defense admitted and played in closing parts of the surveillance video that was never discussed in trial. The state objected. The question was,
Okay.
when you put the entire surveillance video, say it's 2 hours of evidence, and you only discuss at trial 1 minute of that surveillance video, whether the defense was allowed to.
Well, it's kind of the catch-22 things, okay? Because the rule of completeness allows you to admit the entirety of the document. Now, there may be other pitfalls of admitting that document. So that's why you, as the advocate, I'm sure probably need to make sure that if you decide, hey, I want that whole thing in there, it's going to cut for and against.
In a catch-22 moment, Your Honor, you rule for the defense. Why? Because only the defense has the right to a fair trial. Now, I know there are a lot of judges, this judge included, who believes that both sides have the right to a fair trial. That is false, completely false. In the Constitution and Bill of Rights, the only one who has rights is the defendant, not the prosecution.
So you need to be careful, and you need to make sure you have a great understanding of the entirety of that document, so you don't have issues that kind of come up. And since I haven't, since I haven't seen Simmons, and I don't know kind of the parameters or left or right limits of that, I can't really give you any more guidance on it.
Really goes on before more judges are happy, judge, because when the state, I'm just letting Your Honor know, when the state brings forth hundreds of pages of my client's Instagram records, and they're saying, well, we just want to get it in for this one particular purpose, I'm going to have to hold proceedings and say, well, let's have an inspection of every single piece of paper.
Well, that's up to you. Here's the thing. I'm telling you that you either can do one or two things. You can either acquiesce to the state and say, okay, those 4 are fine. Or you can say, under the rule of completeness, judge, we want it all in. Okay, but that's up to you as an examiner.
Judge Glanville, now you're doing it again. Now you're blaming the defense. Even when they try to do it in a timely manner, you get angry. And then, a while later, when they bring it up again, you get angry because they didn't do it in a timely manner. There's no winning against you, because you will hold everything against the defense either as a sword or as a shield.
As an advocate. So, but you know, that's your call at that point in time, Mr. Shard.
We left off, we were talking about how individuals at the Cobb County Jail can make calls. I believe first you talked about pins by having a pin. Were there other ways that you could search to identify if a certain person was calling?
Yes. So
question from Gigi. I've heard it argued that the state is representing the victims' rights. Is that true? No. The victims' rights are guaranteed through the process of a fair trial, through the process of allowing evidence, proper evidence handled. But overarching that is one thing, the presumption of innocence. That is overarching. The presumption of innocence is what differentiates us against ISIS, communist states, Islamic states who do not believe in due process. That is what differentiates us. Due process and presumption of innocence. Now that means, sadly, for many, many victims, that they will feel overrun. But if we don't have due process and the presumption of innocence, how many more innocent people are going to get convicted? We see it all the time. People who there's absolutely zero evidence against get convicted, then a couple of decades later, they are exonerated, spending most of their adult lives in prison. That is what we are trying to avoid.
We can request that the PIN be searched, but we also request the numbers dialed be searched as well.
And why would you request for the search to be done by numbers dialed?
Inmates use each other's PINs all the time.
Now, as it relates to Jimmy Winfrey, the calls that you received, were they?
Ugh, I can't. And more pictures. And you know what that is? That is sidebar counter 172. 172 sidebars. Now, this is from day 75, which was yesterday. And it's not actual 75 trial days. You have to remove 10 days that were administrative days. So we're down to 65. Then you have all the half days. Now remove another 5. Now you're down to 60. Then you have Jesus Christ, the judge cannot be on time if his life depended on it. His 25-minute, 10-minute breaks. His 90-minute, 1-hour lunch. I mean, we don't actually have that many trial days. Let's go on.
You go fully as well.
And what's that? That is another sidebar. It's sidebar counter 173. Yeah, and as Pi says, the victims already had trials. The state has circled back with this RICO using the same defendants in cases that had already been litigated and sentenced, using them as witnesses against defendants. Yeah. All of these cases in the RICO Act or the RICO charge, people have pled guilty to. The defendants have been no charges brought, charges dropped, maybe not even arrested. But RICO allows the prosecution and the state to have a second bite at the apple. That is what's going on here. Remember the guy who had half his head shot off? He didn't even know that his case was already litigated and that Pee-wee, no, who was it? Murphy? I don't care. He took a plea deal. 10 plus 10. the prosecution didn't even bother to tell the victim that they offered his shooter a plea deal. So he went up on the stand thinking, this is the first time this is prosecuted, which is a lie.
Not do gunshot.
Oh. And they are playing something. I guess it's a jail call.
90 what? 9444.
Dun dun dun. And another sidebar. Yeah, I know this is a recap. There's not much. I'm just pushing through. 174.
State, I think you were about to respond to Mr. Steele's assertions about the indictment and YSL being our witness testifying about them being a criminal street gang.
Yes, Your Honor. So first, there was the assertion that Investigator Racy had to be a expert to talk about the fact that his investigation led that YSL is a gang. That he does not need to be an expert. That is what his investigation revealed. Within the indictment, Your Honor, while the specific charge identified the blood gang, when you look at the preamble or the background of this indictment, especially the RICO charge, it talks about YSL and YSL being a blood gang subset. And my next question I was getting ready to pose to him before the objection is,
Here's the thing. When that case handled back in 2015, not a single word about bloods. Nothing.
Said subset. Tell me, what do you mean? So he could have elaborated as to what.
Not even a word about YSL
which was
in
the
that
charge says
plea
blood
deal.
gang. However, he knew and learned from his investigation that YSL was a gang. Why is this important? If you listen to this call, Your Honor, he talks about in the indictment that it said YSL Enterprise. And so at that moment, he asked Amina to put him on the paperwork. So it looks like, well, he tells her, I need you to put me on the paperwork. And then later on, he tells his girlfriend, remember to tell Amina, put me on the paperwork so it doesn't look like street business. And so what I have to get the witness to testify and the jury can believe or not is, well, what did you understand it to be before? And why is that significant that he needed to be placed on paperwork so it can look like it's not street business?
Yeah, I remember us talking about this last week, so.
And so it puts the call in context, and that's why we went to that line of questioning.
Anything further, Mr. Steele first and then Mr. Sharp? Because I did cover this last week. We covered this already, so.
Your Honor, I don't understand how Mr. Williams is having a trial that's fair.
I'm sorry.
I don't understand, from my perspective, Mr. Williams is not having a fair trial. I cannot cross-examine Mr. Winfrey. Now, this witness is telling us what he means by having things not look like street items.
Shit,
whatever.
I remember.
Okay.
Okay, so.
I don't understand how any of this is coming in. Amina Diab is not a witness that the state is calling at all. I don't have a burden, you keep telling me, which I know the law, but you keep telling me that, but it feels like I have a burden.
Sorry, I did a
because
clickety
I have to
clackety.
clean all this mess up. And the
If you choose to do so, sir. And that's your characterization of it, so.
The indictment, quote unquote, redacted is a farce. This thing has, I don't know if you looked at your copy, there's blanks here that identify Jeffrey Williams. I mean, you'd have to be a deceased person not to realize that the indictment is charging Jeffrey Williams in it. And the state just goes on like, this is no big deal. You know, I have a big deal. This entire case should have witnesses who are competent to be cross-examined, and they don't. I again object. This gentleman is testifying. He has no basis in saying what Jimmy Winfrey meant or didn't mean. The recording, because of your ruling, speaks for itself. He shouldn't be able to interpret it, just like I can't interpret it. And it was never even done. What the jurors won't know is that Amina Diab didn't give any paperwork. at all.
Yeah,
In fact, what they don't know is that Jeffrey Williams, the state won't probably play it, a recording with Jeffrey Williams where this detective asked Jeffrey Williams, does Jimmy Winfrey work for you as your road manager? And Mr. Williams laughs and said, are you ridiculous? I have real legitimate people. So all of this is the state of Georgia getting out a theory that is not based in fact, and it should not come into this courtroom. This entire, since the state has been allowed to say, does this help the investigation? This case has gone south. Maybe it was south already, but it has gone so south, I can't do anything. Those are all my objections. I'm moving for a mistrial. I have no idea why this gentleman got to say Amina Diak works on the legitimate side of the business. We're presumed innocent. He has no right to say that. And then this indictment is all hearsay under the Brown case, State versus Brown, which the Honorable Court agreed with, yet the state's using the indictment as a weapon. They're saying it says it in the indictment. Mr. Winfrey played Alfred. He's not testifying. You let it in as a statement against his penal interest. Well, that's only against him. He's not on trial. It can't be a co-conspirator statement because it is a statement that does not further any supposed conspiracy because it spills the beans. So for all of those reasons, I mean, we could just use one, but for all of those reasons, I named 3, 4, 5, or 6, I'm respectfully asking the court to strike all of his testimony that goes into anything anyone else said and the investigation. And let's wipe this slate clean and please, I just want to go forward and have people to cross-examine.
This is the second time you've made the same argument, sir. I understand it, and it's your.
He makes it again because it's a correct argument. You are allowing so much crap in Glanville. So much crap all the time for the sole reason that, well, the state alleges under the RICO Act that there is a conspiracy. That is not a carte blanche on allowing everything in. There has to be foundation. It has to be everything. You can't just throw out every damn rule just because it's a RICO. You can't.
It's your right to do so. All right. Unless you have anything else, Mr. Sharp.
Your Honor, of course, I agree with what Mr. Steele just said about Jimmy Winfrey's plea being coming in as evidence against the rest of us when he is not taking a stand. But I'm going to go one further than Mr. Steele because in their line of questioning, they are asking about the indictment that Jimmy Winfrey pled to. And the jurors are following what they're talking about. They're asking about the indictment, their indictment, the plea. And then they say, and what gang was involved? And then the investigator is going to say YSL when we can all look at this indictment, which shouldn't be coming in evidence in my estimation. But if we're going to let it in over our objection, at least let's be honest about what it says. It doesn't say YSL. He pled to the count.
The preamble say YSL?
He pled to.
Does the preamble say YSL?
Preamble?
Does the preamble, answer my question, please.
Sure, the preamble does, but
Okay,
not the
all right.
count.
So you have to read.
See? This judge take every opportunity to word vomit. Does it say it there? Yeah, but that's not the plea. That's the preamble. That is not the actual plea deal. You absolute fucktwat. I said 4 quad. I'm sorry, YouTube. It's the accent. It makes my words sound different when I say them very suddenly. I meant 4 quad and nothing else.
Okay, you have to read the preamble in conjunction with the count. It's just like it's similarly situated to the preamble that you have in this indictment.
But he pled to specific counts, Your Honor.
Okay, but that
The
doesn't mean
preamble-
that the factual predicate of the preamble doesn't apply, right?
No.
Well, I suggest.
Does it apply or not?
I disagree with you completely.
Does it apply or not?
No, it doesn't.
Okay,
It
all right.
does not. He pled to specific counts. And the state really missed an opportunity because they should have made this indictment 3 times as long and they could put the whole story, the whole narrative in this document that we are not defending ourselves against, that we cannot cross-examine, and they could have put it even more in front of the jury.
Okay, all right. Your second argument as to this as well. Okay, anything else, Ms. Holton?
I think the state has said it. Given the jail call that we just listened to, Mr. Winfrey himself referenced the indictment and referenced him reading of it. And so all of my questions followed through based upon that jail call. given that this was an open pending investigation at the time that this jail call was made, this is relevant areas of what was relevant to Agent Racy at the time when he heard this jail call, which is there was an indictment, it was open, and now in the midst of his investigation, Mr. Winfrey is asking to be put on the paperwork. We can infer it's the legitimate side of the business. Now, if Mr. Steele wants to argue that this DIOP was not a part of the legitimate business, they've been arguing throughout this entire trial that YSL is a music label. So that would be the legitimate side of the business. If their argument is no longer that doesn't exist, then we can move on. But for the purpose of this call references him trying to get put on paperwork so it doesn't look like street business. Paperwork, legitimate, street business, not legitimate. And so we are trying, this became relevant to him, Your Honor. And given all the reasons that we have stated before, this wasn't spilling the beans. This was him trying to cover the conspiracy, which was him shooting at the bus involving Mr. Dwayne Carter. So for all the reasons stated, Your Honor, we would exit. You said overrule the objection.
I'm going to overrule the objection. Mr. Steele, I will give you a continuing objection. I'm going to note that you moved for mistrial once again. I'll also note that you have asked the court for a mistrial again before the positing of the next question. So with that.
I'm joining the motion for mistrial. And also, I'm asking you, in granting that continuing objection, I'm granting it to all of you.
The Harvey rule applies unless otherwise stated. So it would apply for all of you. The motion for mistrial as well as the continuing objection.
I'll ask for a motion to sever parties then.
Okay, I'm going to deny that motion at this point in time, sir. And I will deny that as well at this time. Okay, can we call?
Guys, I'm sorry. Can we ask the court to give a move to strike the testimony regarding legitimate side of the business?
No, sir.
For the jury.
No, sir. I'm not gonna strike that at this point in time.
I don't think the court is recessed. At least this is her.
Yes, you may. Yes, all of you can have a comfort breakout. Why don't we take 10 minutes? Okay, all right.
And then the world's most boring man keeps talking.
Having to get on the paperwork. Was there anything else of significance?
And then we're done with yesterday. All my troubles seem so far. Okay. We got through 2 days in 2 hours. That is the level of absolute nonsense that happened Monday and the final day of last week. Oh, for fuck's sake. You can't be serious. They moved the start of today to 7 p.m. They moved. This should have started. Oh, no, 7 p.m. my time, 1 p.m. your time. That today should have started at 11 a.m. your time. And now, 1 p.m. That is why I sped through. I mean, I could have extended the pain to all of you. Yeah, and remember to add 1 hour for Judge being late. Oh, for fuck's sake. So we are talking about at least another hour before today's trial starts. Folks, I'm good at this, but I can't entertain you all for a full hour of nonsense. Folks, my lovely people, we will go through this tomorrow. I will start tomorrow's stream around 10 a.m. your time, same as today. And yeah, that was unexpected. I was so focused on today actually moving on. Jesus Christ. Well, not much to do about it. Let's see here. Who is... Well, we have there's another trial. I'll send you over to Sal, who is doing another trial. And yeah. Okay. That was that's not what I expected. I was so full. Oh, I'm going to do this for another couple of hours just to, yeah. But we're not getting there today. So yeah. Thank you all for being here. Thank you all for showing up, for allowing me to do this. Thank you for the super chat, JG. Thank you so much. You know you don't have to, but thank you so much. The occasional super chat and gifted memberships is what keeps this channel afloat. I still do have costs doing this, and maybe in a couple of years the channel have grown enough for me to actually make some money out of this. So I'll see you back here tomorrow, all of you, and bring friends. Until then, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Okay, folks? I'll see you tomorrow. Bye-bye.